So we are officially live on YouTube. We're officially live on Zoom. Shanza, happy Tuesday. What's up?
Happy Tuesday to you too. How was your day?
Today was busy. It was my first day back from a leave this weekend. So
Oh yes, you were on vacation.
I was on
Where were you?
vacation.
Where'd you go?
I was in amazing, beautiful, exciting Las Vegas.
Oh my
So
God.
So I needed a couple days and celebrating my best friend's engagement. And now we're back. We're ready to roll, catching up on emails, doing all the good things that we do. And yeah, that's about it.
Okay.
But in any event, I see that we have some people starting to come in. So what I'm going to do is probably start with the intros. And then I'm assuming by 5 o'clock we should all good and we can discuss the substantive stuff that we're about to speak about today.
Sounds like a plan.
Perfect. So, everyone on YouTube, everyone here on Zoom, welcome to Family Law Now After Hours. Today's topic is how to deal with parental alienation, something that we get so many questions about. So, I'm actually very excited to be diving into this topic today with Shanza. The both of us are going to provide you with tips on how to identify alienation, respond constructively, and support your child through the process. Parental alienation can be one of the most heartbreaking challenges parents face during or after separation. And we are here to help. We're here to provide you with some great tools and tips and tricks, and just substantive legal information to help you navigate this. If you are joining us on Zoom today, please use the Q&A feature to submit your general comments or questions about this topic. We love hearing about you. We love your questions. It makes our job speaking to you that much easier, especially if we can help answer some general topics and questions. However, for specific questions about the details of your family law matter, please contact our team directly here at Russell Alexander or a lawyer in your area. If you are on YouTube with us today, you will not be able to take part in the Q&A feature. So that is your incentive to register with one of our events. I'll explain how to do so at the end of our show. That way you can join us live via Zoom and take part in the Q&A feature. The purpose of this series is to discuss general information on separation, divorce, and family law matters, and any information provided here today should not be construed as legal advice. And stay tuned until the end as we will be sharing how you can schedule a free initial consultations with one of our lawyers here at the firm. Now to introduce our panelists, or I should say panelist, because I just have Shanza here with me today, but that's okay. Shanza is a dedicated family lawyer with a strong focus on compassionate and effective legal representation. Her background in business management enhances her strategic approach to legal matters. Shanza excels in negotiation, achieving favorable settlements through strategic dialogue and strong advocacy for her clients. She prioritizes clear communication, ensuring that clients are informed and empowered throughout the legal process. Then there's me. I am a compassionate family lawyer driven by a deep desire to support families through challenging times. And with a background in commerce, I bring strong negotiation, analytical, and critical thinking skills to my legal practice. And during my articling period, I gained confidence in handling a wide range of family law matters. I emphasize active listening, clear communication, and empathy, fostering a comfortable environment for clients. I am certified as a collaborative lawyer, as is Shanza, with the Ontario Association of Collaborative Professionals, and thus we offer clients an alternative dispute resolution approach to avoid court. Outside of work, I am a dedicated Toronto Maple Leafs fan and an LA Rams fan. Enjoy playing hockey, love comedy movies, and if you ever need to find me outside of work, I will be at the ACC or the Scotiabank Arena watching the Leafs play. So you can always find me there if you ever want some legal information. All right, so with that, let's get started to the crux of our discussion today, how to deal with parental alienation. And the first thing that I'm going to dive into, focusing today, is recognizing the early warning signs. So that can be either sudden hostility or rejection, and sometimes those signs point to alienation. So parental alienation refers to a situation where a child becomes estranged from one parent due to psychological manipulation by the other. And in Ontario, um, while the term itself, parental alienation, isn't explicitly defined in the legislation, whether that be provincially or on a federal scale, the courts do recognize the concept under the lens of emotional abuse or coercive control, and it actually does tie into the best interest of the child test, which I'll speak to. But some red flags that I'd like to point some people towards, and maybe thinking, hey, is this something that is leading towards parental alienation, or could this maybe be something else? So I'm going to be providing some of the red flags that I typically provide my own clients when we're having these discussions. So the first one being that the child or the children, obviously if there's multiple children in the relationship, if the child or children suddenly expresses disappointment, I would say disproportionate fear is the term I would use. Disproportionate fear, disproportionate anger, or disproportionate hostility towards one parent. If the child's reasons for rejecting a parent are irrational, or maybe they mirror the alienating parent's language. If the child exhibits guiltless cruelty, I love that term, but it's when they if they go on about being really cruel in the sense that they're not remorseful of the actions or the terms that they're referring to the other parent, if it's guiltless, if they refuse contact, or if they even deny past positive relationships with that parent, I would say that's a red flag. And the last one I like to remind or inform my clients with respects to red flags is that the child or the children uses adult-like language, or sometimes they'll even use legal phrases when discussing one parent. Oftentimes, you have a 5 or 6 year old using phrases such as custody or parenting time, and those types of words are not in the vocabulary of a 5 to 7 year old child. So oftentimes that may suggest some sort of coaching by one parent. So these are things to look out for. Um, in terms of a legal reference that I guide clients to, the Ontario courts, they assess these patterns in light of the Children's Law Reform Act. So, short form, we call it the CLRA. So, they look at the Children's Law Reform Act as a whole, as well as the best interests of the child test. So, the best interests of the child tests can be found in the Children's Law Reform Act. If we're dealing with married spouses, we can also find that in the Divorce Act, but primarily speaking, in simplicity terms, we usually like to use the Children's Law Reform Act for these issues, as well as the best interest of the child test, which can be found again in the CLRA as well, and the Divorce Act in terms of amicable, collaborative, um, child-focused manner. But if that's not an option, or that's being stonewalled, or parties do not see eye to eye on certain issues, or they can't work it out amongst themselves, then of course this will then include potential court action via an application. And likely speaking, we would like to get therapeutic intervention involved as soon as possible, either working with a psychologist, family professional who deals with parental alienation, or any other therapeutic practices. But again, if this is not something that's agreed upon by both parents, then we get into the mix of actually seeking for court-ordered reunification therapy, parenting assessments, and potentially if there's an already outstanding court order or agreement in place, whether that be a separation agreement or a parenting plan, then we look at seeking whether or not adjustments need to be made, and if so, that would be done through a motion to change. So a lot of information thrown out to everyone here. Just be very mindful of the red flags. That's extremely, extremely important. Shanza, anything to add to that?
Those are great points, Joe. And I like how you started with recognizing early signs because you want to catch those and you want to get professional help or intervention as needed, either court or lawyers or negotiation mediation. You want to get to that as soon as you can before your relationship with the children further deteriorates. So I'm really glad that you started with that.
For sure. So, now we've discussed the early warning signs. So, let's just say that you have a client walking into your office, right? And they're telling you parent X is doing, Y and Z. How do we avoid, this retaliation? How do we avoid your client then bad mouthing the other parent, maybe in front of the children? What would you tell your clients on that front?
The example you just gave me, and I want to say in moments like that, for parents who are dealing with this, as difficult as it may be, one of the most critical things that you can do as a parent for your child is to remember to avoid retaliating and avoid bad-mouthing the other parent. It's a natural emotional reaction. If you hear bad words, you want to respond, you want to defend yourself, and you want to call out the other person for everything they are doing wrong. Especially if you feel that you are being misrepresented and you're not being heard, and you're being alienated yourself. So, but what I will advise is don't do it. It only pulls the child deeper into the conflict. It puts them in an impossible situation where they feel like they have to choose between different sides, where they feel like they're the ones who need to step in and manage these adult problems that they never really asked to be a part of. The children, they want to see their loving parents. They don't want to be involved in any of these problems, in any of the parenting issues, custody issues, decision-making issues. They don't understand these terms, and they don't need to be a part of these discussions. Our role as lawyers is really, to answer your question, Joe, is to remind parents as we are working with our clients, as I'm working with my clients, I consistently remind them, stay calm, stay child focused. You know, um, you excusing bad behavior from the other parent is something you might have to do. You do want to protect your child's emotional well-being, even if you feel angry, even if you feel hurt. Those conversations, they belong with your lawyer, they belong with your therapist, they belong with your support network. They don't belong with your child, or your children. So the focus should always be creating a safe, supportive place for the child where they're allowed to love both parents without any fear, without any pressure, and without any guilt. And that's one of the best ways to mitigate the effects of alienation. That's the first thing you want to do before it escalates. And this is also something you want to show to the court. When you go to court, you don't want to go with evidence that shows back and forth arguments, accusations between parents. What you want to show the court is your efforts to maintain, a child-centered approach, and you want to show your efforts to, remain reasonable throughout this whole process.
I'm muted. No, 100%. And I mean, if I can just, add some additional points, um, ultimately, bad mouthing or undermining the other parent can be seen as emotional harm. And what happens is, as you mentioned, it affects parenting time or decision making responsibility, which we don't want, right? If we're entering into especially if we're going into court, you want to be in the best possible position suited to advocate your interests, and having your lawyer being able to advocate your own interests in a manner that is not based on solely assertions, but that there's evidence to actually support the claims that you're putting forward. So we expect each parent to promote the child's relationship with the other parent. But if you notice that the other parent or even yourself, you're engaged in the bad mouthing or the undermining, it can really negatively impact your standing with the court. So that's very, very important to consider. Now taking a separate jump, um, now we're sort of necessarily focusing on the other parent, right? So it's the parent who maybe feels as though they're being alienated or they actually are going through the alienation. And what I would like to say is that maintaining a consistent presence is extremely important in your child or your children's lives. So being a consistent and stable presence in your child's life, and that's emotionally and physically, really does challenge the narrative um, that you're irrelevant or harmful, right? Like if you have parent A saying, "Oh, parent B is not around," um, they are not involved in the child's life, right? These are things that if you're being consistent and stable in your child's life, this really challenges that narrative. That really does challenge those assertions by the other parent. Um, Courts look at parenting history and patterns of involvement. And under the CLRA, the Children's Law Reform Act, your historical role and continued efforts matter. That's something for you to really understand and consider. And failure to attend parenting time may be used to justify reduced parenting or even sole decision-making responsibility to the other parent. So if you are currently going through a process where you feel as though you're not being actively involved in decisions relating to your children, or maybe you're not actively having the parenting time with your child as a result of the other parent, when you're given a bone in the sense that you're being given parenting time, take advantage of that. Um, do not attend parenting time. I know I threw a double negative in there, but make sure you're attending parenting time. It's very, very important. Make sure you're constantly emailing or communicating with the other parent, asking them, hey, what are you doing about XYZ? I would love to stay informed. I'd love to give my opinion on certain things. Showing that you are actively involved or actively trying to be involved in the children's lives, despite what the other parent is doing and the obstacles they're throwing at you, is extremely, extremely important. So what I tell parents going through this, before we're even engaged in the court realm in the litigation stream, and we're sort of working towards those initial steps about how we're going to move forward, I would tell my client if they feel as though they're being alienated, always show up for scheduled parenting time. That's number one. And that's even true. You should still be showing up even if the child resists or the other parent interferes. Show up, show up, show up. If parenting time is denied, follow it up in writing. Don't walk away quietly. You should always be preserving the record. Right, that's really important. And it shouldn't be a phone call either. It should be either email or text message, or sometimes if you're using a communication platform such as Our Family Wizard, make sure you are preserving the record and documenting everything, right? The third thing I like to tell my clients, if they feel that they're going through this issue of parental alienation, is to participate in school activities, extracurriculars, and medical appointments. Very easy to contact the school and get a copy of your child's report cards, their school schedule. These are things under the Children's Law Reform Act you are entitled to as a parent. As long as there's no court order or separation agreement stating otherwise, you have the legal right to access educational records. So follow up with the child's school, follow up with the child's doctor, be involved. It shows that you care, and the narrative or the assertions that the other parent is putting forward is simply untrue and unjustifiable. Um, a final strategy, like I like to tell my clients, is utilize technology as best as possible to maintain engagement with your child between visits. So calling parent A, asking to speak to the child, um, maybe using FaceTime or WhatsApp video, even sending recorded videos, right? These are all great things that you could be doing, especially if the child's older and they have their own phone. These are great tools that you can be engaged in. And with that, Shanza, do you have anything you'd like to add on to that?
Yeah, I'll kind of like build up on everything you've said about, maintaining documentations. Um, it's really critical for parents to document all these things, these incidents, and not just incidents, but also behaviors that raise these kind of concerns. So, like Joe said, keep, detailed, factual records of these interactions that you have with the other parent. Communication, even if you're noticing, for example, changes in your child's attitude, even this can be, valuable information. So keep records, keep notes. If you are in court, the more detailed information that you can give to your lawyer, the better they can advocate, the better they can prove your case to the court. So these records, they're not just about, you know, building a case to win. Like every time you're in court, there's misunderstanding, there has to be, a winning side or losing side. It's not about winning against anyone. It's not about winning against the other parent. These records, they serve as an objective tool. So they are an objective tool to understand what's happening. It helps identify lawyers, professional judges, anyone who's helping you through this process. It helps them identify what's going wrong, where it's going wrong, and the whole idea we're here is to provide you with solutions. So this evidence is needed for professionals to intervene and to help appropriately where and when it's needed. And Joe also mentioned on parenting apps. So one effective way that you can document your interactions, with the other side is go on the parenting app. These are specifically designed for co-parents to communicate. And the whole purpose of these apps is documentation. These apps, they allow parents to log in their exchanges, their parenting time, expense of any concern, and it allows like a very clear, time-stamped way, in a very easily, accessible and readable format, in which, it's easy for lawyers, for professionals to really follow the communication that went, that happened months ago, years ago. So it gives like a very, very organized way of following the information, of following the interactions that occurred between you and the other parent. So if you feel like there are concerns, about the other parent withholding the child, if there are concerns about alienation, get on the app. If you have a lawyer, talk to your lawyer about it. I have clients where the major issues are parenting, and I am always telling them if there's a missed call, document it. Send a message to the app, let them know, hey, you didn't call, the child was waiting. Make sure you're keeping all these records, and the app is a great way to do it. Um, and this good communication, this good documentation, sorry, it shows that a parent is engaged. It shows you that you're attentive. It shows that you're proactive. It also shows that you're not reactive or vindictive, which is what we are trying to prove. The whole idea, again, is not to prove anyone wrong. The whole idea is to show that you care about your children. Your priority is their well-being, that you're being attentive, you're being engaged, and you're being proactive, in terms of, how your relationship with the kids is unfolding as the separation process goes ahead. And it really helps to keep the focus on the child and their well-being. And if any situation again escalates to court, the app's documentation is your best friend. So while being consistently present, um, you know, if you are being consistently present, you do want to make sure that you are following ahead, but also documenting everything. You're, keeping notes of dates, times, what was said, what was done. Um, if there are any witnesses, that did witness any interaction that occurred, keep note of everything. You never know. You might need that information later on if you find yourself in court, if you find that your matter is escalating. Um, and this approach helps protect the child. And the whole idea is to protect the child, and that's really why we're doing all of this here. Um, yeah, I think that was pretty much, I think we those two of us covered. If I've missed anything, Joe, feel free to add anything there, but I think that was a good overview.
Yeah, I think that's great. While you were you were giving off some amazing points, we actually have a couple questions that came in. Either it was from what I said or what you said. Um, there's one question here. I'm just taking a look at. Um, what would you do if the other parent ignores the emails, threatens harassment charges for contacting through emails, accuses parent emailing of being the step parent emailing and refuses contact? So what I would do in that the question goes longer, but what I would do ultimately if you find that you're in a situation where you are not having fulsome communication with your child, I would speak to a lawyer and discuss your options. There's various options that can happen, but you should be having fulsome, frequent communication with your child. if whether or not you're the resident parent or the non-resident parent, you should still be having that active communication. There should be a determined parenting time schedule where it's quite clear as to when each parent has parenting time with the children. And if you are finding that the other parent is not adhering to the parenting time schedule, maybe that you've informally created with one another, or you find as though that you are not speaking to your child as frequent for various reasons, um, I would definitely speak to a lawyer, and you would need to get the ball rolling on ways in which you can resolve this. Again, there's numerous ways that can be resolved that this can be resolved. There's alternative dispute resolution, so going through mediation, collaborative practice, or the collaborative family practice, which I am licensed, and so is Shanza. It's another way in which um, parties can work together in a collaborative manner to formalize an agreement. And then ultimately, if you find as though that those realms are not working, or maybe communication has totally ceased between you and the other parent, or maybe if you retain a lawyer and that other parent, or they don't get back to you, then you would have to take the steps necessary through a court application in order to ensure that you are having frequent and substantive parenting time with your child. And again, that's going to be in the child's best interests in terms of duration. So everything revolves back to the children's best interests. So if that is in the child's best interest, then that should definitely be something that's going ahead along with. So, we've discussed a lot of the parenting aspects. We discussed the documenting, but now we're going to focus more so on the child and seeking support for the child going through this issue. So, children in alienation situations often experience emotional distress, loyalty conflicts, and anxiety. And as such, the parents, Shans and I, we are not in a position to be providing this assistance to the children. And more often than not, or I would even just say predominantly, professional help is key and is necessary. We do have some methods in which the court may order assessments or therapeutic intervention, and that's done through Section 30 of the Children's Law Reform Act. And Section 30 is a way in which private assessments or even compulsory therapeutic interventions can be ordered by the court if this is being engaged in the litigation realm. Um, and as such, if this does occur, then therapy records may become part of the evidentiary record. And depending on privacy issues and the child's best interests, those are two things that come into play, whether or not that's whether that's looked at. But more often than not, they are. Um, there's also what's called a Section 112 assessment, and that's through the Office of the Children's Lawyer. And that's when they have the opportunity to interview the children, and they can provide either a voice of the child report, they can provide a clinician to do an assessment, or it can even get to the point where they actually act as legal counsel for the children. And that's to ensure that the children's voice is not being manipulated by their parent, that it's their wishes and best interests and present preferences are being put forward. So there's no manipulation involved in that area. Um, what's great about the Section 112 assessment is that the services provided by the Office of the Children's Lawyer, they are a government service. They are free of charge. However, they are not guaranteed to be appointed to your specific family law matter. There are a lot of families who are vying for these services, and the services that they offer are quite limited. So that's the sort of the downside. The Section 30 assessment is something that you can almost guarantee get. However, it's not covered under provincial resources. It's something you do have to pay out of pocket for, and those assessments are quite expensive. Um, but in terms of maybe you're navigating this issue outside of court and you're going through the negotiation process, or you're just starting out, it's really important to float the idea of seeking a child psychologist, someone who maybe has experience in high conflict divorce, high conflict separation, or someone who's engaged or has been engaged with the teachings of reunification therapy. Those are things that I would like to look out for, or I tell my clients to look out for in terms of when they're selecting a potential professional. Um, Another thing I like to tell my clients is that they should be avoiding unilateral therapy decisions. Decisions should be made in conjunction with the other parent. If you do not have a court order or you do not have a separation agreement or parenting plan, there is what's called de facto joint decision making. So you both should be working together to be making material or significant decisions for the child as it relates to education and healthcare, and therapy does fall under the healthcare realm. Again, if you do have sole decision making responsibility, then that's different. You can engage in those unilateral decisions for therapy. However, you should still be making the other parent aware of what's transpiring. And um, if there is joint decision making exists, and again, there always is de facto decision making unless there is a court order or agreement stating otherwise. Propose options formally via counsel. So if you feel as though you're not getting through with the other spouse and you feel like you've both hit a roadblock, if you both have counsel, then this should be something that should be communicated between counsel. And being able to propose options is never a bad thing, right? And what I like to do when I'm reaching out to opposing counsel, if this is an issue that arises, is I like to frame the therapy as support for the child and not as an investigative tool. So I really make my communications child focused, resolving issues in a child focused manner, and sort of not framing it as being investigatory or as a means for creating an evidentiary brief, more so as the parents are going through one of the most stressful times in their life. By association, the children are going through one of the most stressful times and emotionally draining and emotionally straining times in their life. Let's get the child the help that they need, and whether or not they verbalize it or not, because children usually at a young age are not verbalizing that they need help. It's the parents' duty to be ensuring that the children are looked after. So with that, Shanza, anything to maybe tackle on with, or
Yeah, I'll just add that sometimes even, negotiations might not take you where you want to go. So let's say you have counsel and you are engaging in negotiation where, you are proposing therapy for the children, but for whatever reason, the other side is not being receptive, then if you are in litigation, then, get this issue conferenced. Go in front of a judge. And a lot of times, if you have some documentation, something that you can point out to, this is the language my children are using, or, this is where I called, my parenting time was cut off, I was not responded to. So as long as you can point to something, from the other side that the judge can tag on to and be like, okay, this is not okay. This needs to stop or this needs to be fixed. So if negotiations are not going anywhere, then, sometimes you really just need that input from a judge or, someone with authority who can really tell the parties off and get the other person to negotiate with you finally, right? Or give at least some direction as to where you can go from there.
sure, 100%. And I mean, let's just say we're going through the process. Maybe both parties have retained lawyers. How do parents communicate respectfully despite the conflict? Because it is possible. And just because that there's a conflict doesn't mean that you still cannot show humility and respect in your communications. So what do you advise your clients?
I'll start with communicating respectfully is absolutely critical in any co-parenting relationship. And I know we keep talking about it, it looks good even to a judge or even if you're not in court, even if you're not trying to build up a case, again, you should still document everything regardless of where you see your file headed. But, you know, even if the other person, other parent, isn't doing the same, you can still communicate respectfully. As I've mentioned before, and we've talked about this, me and Joe, since 5 o'clock. When parents are able to, remain mature and they're able to remain civil and focused on the child's well-being, then it does create a more stable and supportive environment for the child. And that's really all you need. to maintain that communication, right? So if you know that this is what's best for my child, then it comes easy to parents to remain respectful, to fix their communication, or to at least make sure you're not engaging in a lot of arguments and back and forth. Um, because at the end of the day, what you're really focused on is your children, how they are affected by this dynamic between their parents. And when the dynamic is consistently tense, it will lead to, and it can lead to confusion, anxiety, emotional distress for the children. Um, and if one parent is being difficult, then it's your job as the other parent to try to maintain that calmness for the children and try to maintain that respectful communication, as your ultimate goal is to reduce that conflict for the children. Um, Again, even from a legal standpoint, this is important. Courts will look at your conduct. They will look at how you're communicating. They will look at what you're doing. Um, because the whole point is not proving the other side wrong. Again, the point is that you are a suitable parent to parent your children. That you are, mentally and physically and emotionally in a state where you can have parenting time with the children. And when a judge is granting you parenting time, not only are they looking at the other side's behavior, but they're also looking at your behavior and whether you are in a position to be able to have custody or have proper parenting time or have decision-making authority for the children. And it's a practical necessity too. Co-parenting means, regular communication on everyday matters. Could be school issues, could be healthcare decisions, could be extracurriculars, holiday. So if you're co-parenting, you cannot avoid the communication. It has to happen to some extent. And so that's another reason why you want to keep it respectful because it's something you have to do. And you would rather have a workable co-parenting relationship with the other parent than be constantly engaged in conflict, constantly having to have lawyers communicate on your behalf or for you, or being engaged in a lengthy court battle. You do want to get to a point where you're able to communicate with them and you don't have to rely on lawyers or other professionals to do this every day communication with the other parent because you will be co-parenting. If you have young children, then that co-parenting timeline is going to be very long. So if you're dealing with if you have a 5-year-old, 6-year-old, then you're co-parenting until they're 18. It's a lot of times co-parenting relationship goes on after your separation and divorce for a long time. So you do want to maintain that civility. You want to be able to communicate without having to rely all the time on outside help. Ultimately, committing to respectful communication, it's about safeguarding your child's health and, the focus is always on them and what's best for the kids.
Amazing, amazing. Um, you hit the nail on the head there, which was like I was gonna like maybe find something to say in addition, but you really covered everything. So, now focusing on, what's happening in the background, but as you mentioned, we can get to the point where legal options need to become available, and they may be necessary in terms of the alienation escalating to a point where maybe you're not being able to see the children any longer, or you're not getting those phone calls, and when that happens. You need to get your feet moving. You need to get on that horse and start working through this as quick as possible. There's a wide array of options that can be of assistance to you. Um, and also this is understanding that a lot of people come from different social brackets, different economic groups. So I mean there's no right or perfect path that one person can take because of course circumstances are different for everyone. So what I'm going to provide here is just some basic ideas and that should help, kickstart any assistance that you may need to help resolve this in as timely of a manner as possible. So the first being, of course, is going through the litigation realm, going through court. So that would be either yourself or you retaining a lawyer to move forward with an application, and that gets you in the court realm. That gets you in the litigation sphere. However, before proceeding with litigation, I always like to recommend that parties engage in alternative dispute resolution if possible. There's a duty under the Divorce Act, as well as a professional obligation that clients be made aware of alternative dispute resolution methods and that they engage or at least attempt to engage in those processes first before attempting or before proceeding with court. Again, there's various alternative dispute resolution methods that can be engaged in. The first and the most common is mediation. Mediation deals with a third party mediator, and their job is to listen and help generate some ideas for resolution. They don't provide legal advice. Rather, they just listen to both parties' sides and they try to help both parties compromise and come to a fair and equitable agreement. There's also the collaborative practice, which again is something that Shant and I are both trained and certified in. And this is where the parties each retain their own lawyer that is collaboratively trained. And then depending on the issues, so if there's parenting issues, a third party neutral parenting professional, such as a psychologist or a social worker, would be involved. And if there's financial issues, then we'd also retain, or the parties would jointly retain a financial professional, and we would work the four professionals or three professionals, depending on if there's no finances involved, and the parties on working towards a collaborative child-focused method in coming to an agreement on all outstanding issues. There's also arbitration. Arbitration is very similar to the court realm, except for the fact that it is done outside the court realm. Instead of a judge, you have what's called an arbiter, and the arbiter can make decisions known as awards, and these are binding decisions, and they have the same strength and enforceability as a court order from a judge. Arbitration is costly. However, I would say that it is more cost effective than going through the court system, and it also provides results in a far more timely manner. As it states, I just had a case conference today in Oshawa, the jurisdiction, and our settlements conference dates were not being handed out until the middle of December. So it takes months on months to get court dates and to be able to progress through your file. So being able to work through this outside of court often offers a more timely resolution. Um, if you already have a parenting plan or you already have any other domestic contract, such as a separation agreement, or you already have a court order and you find as though the other parent is not adhering to the parenting terms, then you could either bring what's called a motion to change. So a motion to change will help you vary or change the terms of your agreement or court order based on a material change. Or you could also bring an application to enforce the court order or separation agreement. Those are two ways in which you can go about that. And going through all these legal options, it really provides you with different ways in which to tackle the outstanding issues. Again, ideally, going through alternative dispute resolution is recommended. It is ideal. It helps lower stress. It helps lower the emotional toll of going through court. And then of course, court is the last resort and should be the last resort. What I will like to tell our viewers is that, when looking at judicial trends, in severe cases of parental alienation, Ontario courts have actually transferred primary residence from the alienating parent to the targeted parent. And really, courts are increasingly recognizing alienation as a form of emotional abuse. And this is especially when supported by expert evidence. So, again, it's really important to tackle these issues as they arise, and you do so in a timely manner. Do not wait. The longer you wait, there's a greater argument for the other party that you either consented or acquiesced. Acquiesced means that in simple terms, you went along with the ride, you went along with the flow, and you didn't do anything about it. So really important if you feel as though your parenting time is not being adhered to, if there's a domestic contract or a court order, or maybe the informal status quo that you and your partner have been going through is now not being followed or being unilaterally changed, speak to a lawyer and get your options. You need to know your options and how you should best move forward. So that's dealing with, the legal options available. Um, but Shanza, as I just mentioned, I just had a case conference today, and it's going to be, almost, 7 months before we have the next conference, the settlement conference. So how do you tell, or how do you explain to your clients, whether or not they're engaged in the court process, or maybe they're engaged in the out of court process and they're working on negotiating terms for a domestic contract, like a separation agreement? How do you tell your clients to stay patient through the process?
You are 100% right. It can be a very long process at times. And as I was saying earlier, when I advised about, getting in front of a judge, I was talking about a case that I had where, it was months of the other side not agreeing to therapy for the children, reunification therapy for my client. And it can be a very lengthy process. And I always tell my clients, you know, addressing parental alienation, this is one of those issues that it can be a very gradual process. It will require a lot of patience and persistence from the parent who's experiencing it. Um, so rebuilding trust, let's say that alienation has occurred, and now, we are at a point where the child has been affected. And so, you know, what do you do? You can't just, it's hard to rebuild a relationship enough that your child wants to see you the next day. And so you need to understand that it's going to be a long road. Um, and rebuilding trust with your child, it doesn't happen overnight, but it can happen. As long as you're consistent, you're taking the right steps, you are taking the help that you need. And so it'll take a lot of time and consistency, a lot of patience on the people's end to get to that end road that they want to achieve. And again, if you're in litigation and you're waiting for that case conference date, what I tell my clients in the meantime is you want to take all the steps that you can while we're waiting for this court date or while we're waiting for, to hear from the other side. What we want to do is, again, like, as you're waiting for a decision, engage in therapy as much as you can with the children. And I know we initially hinted at reunification therapy. I don't think we ever really explained it. So, reunification therapy is a specialized form of counseling, and it's designed specifically to help repair and rebuild the relationship between children and the parent. So, reunification therapy typically isn't just the child and the therapist, it's family therapy of a kind where one parent or both parents attend therapy with the child. And these sessions are specifically focused on addressing, alienation, or if a child is feeling distant from one parent. It could be anything, right? It could be parenting style that doesn't match with the child's nature. So these therapists, they're obviously professionals and they know how to deal with these situations, and they're there to help and assist. This therapy is done with trained professionals, and they work with the child, they work with the parent, and uh, yeah, so they're in a lot better position to provide that assistance that might be needed. And so, as you are going through the separation process, as you are going through the court system, if you are in court, um, if you can attend therapy with your child, or maybe the first step could be just therapy for the child, and then you transition eventually to family therapy. Whatever is more suitable for your situation, speak to a lawyer. They will be able to better understand your situation, what you're going through, and they will be able to give you a lot better advice as to what's the steps that you want to follow for your specific case, depending on where you are legally and where you are even in terms of therapy, and how's the relationship and how's the alienation, or what's really causing that strain between you and your child's relationship. And a lot of times, children and parents, they struggle to communicate with each other, especially when they're going through a separation. And so sometimes even having, attending therapy can really provide that safe space, even for the children, for them to, express their emotions, how they're feeling. And so sometimes you really need that third person to come in and allow the parents the children to open up to you. And so it can be very, very helpful. So, if you feel like that is something that you can benefit from, then do seek that help, do engage in therapy as you are going through the separation process, as you are waiting for that case conference, as you are, making your way through different stages of your separation or divorce. In cases with less conflict, obviously parents can agree to do it together, the therapy. However, if if the conflict is at a point where you can't, then obviously you do need the judge to come in, and so you do want to be patient. You want to do the best you can to try to maintain your relationship with the children as you wait for that court date or as you wait for that third, that professional to help. Mediation is also an option. So if you feel like if you're in a position where a mediation could be helpful, then it's always worth a try. So ADR, arbitration, mediation, Joe talked about all of this just now. So if you feel like that's something you can do, go ahead, attend mediation. Even if you are in court, you can go back to court. But mediation can help narrow down some of those issues. And so you can focus on the more contentious items for the court date. Um, Besides reunification therapy, there's obviously also parenting coordinators. And so if you feel like it's taking too long, maybe have a parenting coordinator come in. Again, these are also professionals. They know how to manage conflict between parents and they know how to support, better communication. And so maybe what you need is a parenting coordinator because they can come in and help, both parents try to agree on a parenting plan. A lot of times, what you really need is to sit down with the other side and how a third professional, kind of guide those conversations. And so a lot of times having a PC can be very, very helpful.
100%. Um, yeah, spot on again, as always. Just the last topic that I would really like to discuss with everyone today before we sign off is, you know, let's just say you are the parent, maybe maybe being the one who's engaging in alienation practices. Um, this message or what I'm about to say is, primarily directed towards you. Um, children must never feel caught in the middle, right? Alienation thrives on emotional enmeshment. And it's really important that the children are removed from the adult conversations and the adult issues that are stemming from the breakdown of the relationship. And, courts, they view emotional pressure as, harmful and inconsistent with the child's best interests. And evidence of pressure can support a change in parenting, whether that be decision-making responsibility, parenting time, or maybe inclusive of mandatory court-ordered therapy. And it's really important that you know, you're you're assuring your child that it's okay to love both parents. It's okay to be in a healthy relationship with both parents. Note that both parents love the child, that both parents care for the child. Never ever ask your child to spy or report on the other parent. Uh, Never ask, your child to ask questions of the other parent. Don't involve your child in litigation updates or court proceedings. They shouldn't even really know that you're in court. Um, I have one client, she tells her son when she's going to court that she's going to visit a friend. So little things like that. Your child doesn't need to know that you guys are going through litigation and going through these issues as a result of your separation. And it's really important that when you're having discussions with your children, if you are, and if you're doing it in the right way, that you're actually reframing conversations away from conflict and towards connection. That's really, really important. Courts view that it's in the child's best interests for both parents to be actively involved in the child's life, be able to make decisions together, to be able to co-parent effectively. It's really, really important that this happens. So, I mean, that's sort of my final thoughts on this topic for today. Shanza, do you have any closing remarks?
No, those are great points, Joe. The only thing I'll say is I know like these are emotional matters and people sometimes don't want to involve like outside help. And I get it. It's emotional, it's exhausting, it feels really personal, but the truth is that when alienation is happening, you do need professionals in your corner who actually get this stuff. So, my walking away remarks today would be um, get the help if you are in a position, everything that we talked about today, speak to a lawyer or speak to a therapist, a professional, and get the help.
Amazing. So, with that, thank you, the viewers, both on YouTube and Zoom today for tuning into Family Law Now. Following the session, a brief survey will appear, only on Zoom, unfortunately, not on YouTube, but it will allow you to share your comments and suggestions for future topics that you'd like us to explore. And as always, your feedback is greatly, greatly appreciated. Um, we would also ask if you are interested to book now to take advantage of this opportunity for a complimentary consultation with one of our lawyers. In order to take advantage of this opportunity, please contact our intake department at intake, INTAKE, at russellalexander.com and provide the code SPRING 2025. That's SPRING, SPRING 2025 to schedule your appointment. You do have to send this code in your email to our intake department by the end of day of this Friday. You don't necessarily have to have your consultation with a lawyer by Friday, but if you are interested, this code is only valid until Friday end of day. So make sure if you are interested that you take advantage. Registration is also now open for our next event, How to Set Boundaries with Your Ex-Partner. In order to register, please go to russellalexander.com. It's two S's, two L's, / family law now. Thank you to our panelist, Shanza, for their insight today. She's great. She's so knowledgeable. She's an amazing lawyer, and you want her on your side. And thank you, the viewers, for tuning into Family Law After Hours. We really, really appreciate it, and we hope that you learned a lot today. Thank you.
Thank you so much, Joe, for all your nice words.